any kind of change. The various amendments which have already been made to the Constitution indicate that provisions have been added, varied, or repealed. The meaning and ESCO, P out the amending power J, in the object and necessity for amendment in a written Constitution, for changing the Constitution in an or curly manner, and for making changes in the fundamental law or organic lay veto, change the fundamental or basic principles in the Constitution, the background in which are TICLC 368 was enacted by the Constitutiente Assembly, has an important aspect on the meaning and scope of the power of amendment. The Constituent Assembly made no distinction between essential and non-essential features. No one in the Constituent Assembly said that fundamental rights could not be amended, even in the debate on the Constitution, First Amendment Act. No one doubted the power of Parliament to amend fundamental rights. Proceedings in the Constituent Assembly show that the whole Constitution was taken in broad perspective, and the amendments suggested fell under three categories: providing for simple majority, or 2/3 majority, or 2/3 majority, and ratification by the states. These different procedures were thought of to avoid rigidity. The conclusion is that the meaning of the word amendment is wide and not restricted. If there are no limitations on the power, it is the whole power, 391, 396, 397, 398. There are no inherent or implied limitations on the amending power. The theory of inherent and implied limitations on the amending power is based on the assumption of a narrow and restricted meaning of the word amendment, to suggest that the basic features or the essential features of the democratic republican character of the Constitution cannot be damaged and destroyed. This court in Berubari case F 1960, 3 SCR 250 said that the preamble has never been regarded as the source of any substantive power, because such powers are expressly granted in the body of the Constitution. This court said, 11. What is true about powers is equally true about prohibitions and limitations. The petitioner's contention that the preamble is not a part of the Constitution, and so, being unalterable, other provisions which gave effect to the preamble cannot be amended, has no force. The contention that the preamble is not a part of the Constitution is nullified by the petitioner's reference and reliance on the preamble as the source of all inherent limitations. The preamble in a constitution refers to the frame of the Constitution at the time of the preamble, and therefore, it can possibly have no relevance to the Constitution, to power in the future when that Constitution itself can be changed. The position would be the same so far as the preamble is concerned, whether the constituent power is exercised by the amending body provided for by the people themselves in the Constitution, or by referendum, if so provided for in the Constitution. Clear constitutional provisions are imperative, both on the legislatures and the courts, where a constitutional provision is comprehensive in SKO and leaves no room for interpretation. The court is without power to amend, add to, or detract from the constitutional provision, or to create exceptions thereof. BF implication, where the people express themselves in careful and measured terms in framing the Constitution, and they leave little to implications, amendments, or shan. As in the existing order or conditions cannot be left to inserting implications by reference to the preamble, which is an expression of the intention at the time of the framing of the Constitution. The power to arnens the Constitution is therefore not restricted and controlled by the Pierre Campbell CPUR, Faderni 1, Faderni 2, Faderni 4, Faderni 5, EU Savanandai, Kerala, Ray J. 27 Berubari Call, 1963 SCR 250, Topalan v. State of Madras, 1950 SCR 88, Kamla Tlukotian Bill, 1957, 1959, SCR 995, Bajeshwar Nath VTHCJT, Delhi, Didi Sapasir, Thar 28, Coal Beaming Arthas Act Cast, 1962, 1 SCR 44, Statef Reichstablet Rain, 1965 1 SCR, 276, Secretary of State for India in Council Vaiklar, Mahonra 1AH of Babel 1, ILRH MAD 529, Attorney GTN Trell v. Prine Ernest Augustus of Hanwar, 1951J AC 436 and H. Daneman G. Jacobson Verister, Common Utalth of Massachusetts, 197 US 11 referred to. The theory of implied limitations is a subtle attempt to annihilate the amativic power of amendment. The maxim expressum facit cessare taxtum, 1 of the salutary principles of statutory construction. Rule 6. R. Bura, 3 AC 889, WTB Voutram, 1907, AC 89, Fielding vi. Thomas, 1896, AC 66, Whitman vi. Satter, 1910, AC 514, referred to. The entire approach of the PC Thionker to the power of AMCDCNT, contained in Article 368, ignores the fact that the object of the Constitution TSA, ITC, provide or the organs of state like the judicature, legislature, and the execute IVC for the governance of the country.